Hello everyone, welcome back to part 2 of Flexible Working Understanding Your Right. Today we are going more deeper into the claim and compensation of flexible working. Let's see what happens if a flexible working request is refused. Sometimes flexible working requests are resolved easily between the employee and the employer. But in some cases the request may be refused, and the employee may feel the process was not handled fairly. So what can employees do in that situation? Nothing but look at the legal options available. Yes, an employee can make a claim to the Employment Tribunal. But can they go straight to tribunal? No, they must first contact ACAS for early conciliation. This is a process where ACAS tries to help both parties resolve the dispute without going to court. If the matter cannot be resolved, ACAS will issue an early conciliation certificate. This certificate is required before a tribunal claim can be submitted. Does tribunal can influence the employer decision? No. What we have to understand here is something very important. The Employment Tribunal cannot decide whether the employer should have approved the flexible working request. Instead, what tribunal looks at is whether the correct and fair procedure was followed. So let's see what a fair procedure looks like. 1. Application. As we discussed in Part 1, employees can make 2 statutory requests in a 12-month period, which must be in writing. 2. Consultation meeting. It's mandatory that employers hold a meeting to discuss the request, especially if they intend to refuse it. 3. Appeal right. The employers must offer the employee the right to appeal on the decision. 4. Decision timeline. The entire process, including consultation and any appeal, must be concluded within 2 months of the initial request. 5. Alternatives and trial periods. If the original request is not feasible, employers should discuss alternatives or consider a trial period. 6. Refusal grounds. Rejection must be based on specific, valid business reasons, and the employer must allow an appeal. 7. Record keeping. Employers should keep records of discussions and decisions. Let's see when the procedure may be unfair. The process may be considered unfair if the employer does not properly follow the flexible working rules. 1. Did not handle the request reasonably. This means the employer did not properly consider the request or discuss it with the employee. For example, an employee asks to work from home 2 days a week due to childcare responsibilities, and the employer immediately rejects the request without having a consultation meeting or discussing possible alternatives. This could be seen as not handling the request in a reasonable manner. 2. Fail to give a decision on time. Employers must respond to a flexible working request within 2 months, unless both sides agree to extend the time. For example, an employee submits a flexible working request in January, and the employer does not respond until May. This would likely be a procedural breach because the decision was not given within the required time frame. 3. Rejected the request using incorrect facts. The employer must take their decision on accurate information. For example, an employee asks to work earlier hours, and the employer refuses the request saying, quote, "There is no one available to cover the afternoon shift." However, in reality 2 other employees already work the afternoon shift. In this case, the request may have been rejected based on incorrect facts. 4. Refused the request for a reason not allowed by law. Employers can only refuse flexible working requests for specific business reasons such as additional costs, negative impact on performance, inability to reorganize work, inability to recruit additional staff, detrimental impact on customer demand. These reasons come from the Employment Rights Act 1996. For example, an employer rejects a work-from-home request saying, "I just prefer staff to work full-time in the office." This is not one of the permitted business reasons, so the refusal may be considered unlawful. Refusing a flexible working request could sometimes lead to a discrimination claim under the Equality Act 2010, if the decision unfairly affects employees with certain protected characteristics. 1. Indirect sex discrimination. This happens when a workplace rule or practice disadvantages one gender more than the other. For example, a mother asks to work part-time so she can look after her children, and the employer has a rule that all managers must work full-time, and refuses the request. Since women are statistically more likely to have childcare responsibilities, this rule may put women at a disadvantage, which could amount to indirect sex discrimination. 2. Disability discrimination. Employees with disabilities may request flexible working as a reasonable adjustment. Example: an employee with a chronic health condition asks to work from home 2 days a week because commuting worsens their symptoms. If the employer refuses the request without properly considering reasonable adjustments, this could amount to disability discrimination. 3. Age discrimination. Sometimes flexible working requests relate to age-related needs. Example: an older employee requests reduced hours because they are approaching retirement and want a phased transition. If the employer rejects the request simply because they believe older employees should retire instead, this could be considered age discrimination. 4. Religion or belief discrimination. Flexible working may also relate to religious practices. Example: an employee asks to adjust their working hours on Fridays so they can attend religious prayers. If the employer refuses without considering possible adjustments, it could potentially lead to religion or belief discrimination. So sometimes refusing flexible working is not just about the request itself. If the refusal unfairly affects employees with protected characteristics like gender, disability, age, or religion, it could lead to a discrimination claim under the Equality Act. Now let's see how a flexible working request leads to unfair dismissal. If an employee is dismissed or treated badly because they exercised or plan to exercise their flexible working rights, they may bring a claim for unfair dismissal. In many situations, this would be considered automatically unfair dismissal. Let's see, once the employee approached the tribunal, what could be the outcome? If the tribunal finds that the employer did not follow the correct flexible working procedure, it can order the employer to reconsider the request. It can also award compensation of up to 8 weeks' pay, subject to the statutory cap. Is there any alternative for tribunal to resolve flexible working conflict? Yes. Instead of going through a tribunal, employees and employers may choose to use the ACAS arbitration scheme. This is a voluntary process that can resolve disputes about flexible working or unfair dismissal without going to court. Let's see how ACAS arbitration scheme works. The employee first contacts ACAS for early conciliation, and if the dispute is not resolved, both parties can agree to use the ACAS arbitration scheme, where the type of dispute they covers are unfair dismissal claims and flexible working disputes. Once agreed, an ACAS arbitrator reviews the evidence from both sides, and finally, the arbitrator makes a legally binding decision. Thanks for watching. If you found this video helpful, don't forget to like, share, and subscribe to the channel. I'll be back soon with another video. Until then, bye from HR with Pooja.